Yay, someone actually used the screen name correctly. They figured it out. Okay. All right, let's let who's here. Oh,
Good morning.
hello, everybody. Okay, well, still adjusting some screen names here. We'll be getting to the hearing shortly. All right, looks like the participants have slowed down in terms of joining us. So let me just review. Looks like we have a couple people that I don't recognize based on their screen names. Oh, or did they just drop out? Looks like. Oh no. Okay. So there's a person connected with the screen name VC MSN and then some numbers. Great Bear Forest. So I just was curious if you're connected with one of the parties or commission staff. Just let me know, because the this hearing is for in terms of connecting to Zoom, it's just for parties and commission staff. So I'm gonna have to let you go if you don't answer.
That appears to be counsel for Power and Light.
Oh yeah, look at that, Great Bear Forest. You're right. Kind of interesting. I don't want. Oh, I probably want to get the story about. Let's see. We'll rename you. Interesting. So is that going to be the attorney table primarily, or are you going to have witnesses connecting over there as well? You're muted, guys. I can maybe unmute you from. Oh, I can ask you to unmute. It must be some sort of system here. No, I'm not hearing you yet. All right. Well, we'll kind of need you guys. So we'll see. We'll let you guys work that out.
Can you hear us now?
Oh, there we go. Yes, excellent. So just let me know, just in terms of the screen name, should I put attorneys there, or are you gonna have witnesses there too?
So that will be the attorneys, and then I believe also witness Volk will also be in that room when she is speaking.
Okay.
And then
Well,
our other witness Ashenfelter is on under his own screen name.
okay. I'll probably just add witness Vok when she takes the stand. I'll add her in, but we'll just put attorneys for now. I guess you guys are going to team up, so we'll leave it like that. Okay. All right. Looks like we got everybody. Yeah. So I don't see any members of the public connected. So we do have the live stream going for the public to review.
Excuse me. Can we ask that you unmute the attorney's room? I'm being told that they are being muted through Zoom.
Oh, let me see. No, I don't really have the control of that. It's just it just says ask to unmute. So that's not able, I'm not actually able to control their mic. You're talking about the WPL attorneys that,
Yeah, can you?
Judge, that worked for us. Thank you for sending it again.
okay,
All
yeah.
right.
All right, we're having a little trouble hearing you though. You're kind of cutting in and out. So,
We were double muted, and we can unmute on our end, but not through Zoom. So appreciate it. We should be working now.
Okay, but you are cutting out when you're speaking. So just test it one more time and see if we can.
Yeah, we'll try one more time. We'll try talking loudly. Does that help?
Well, we'll see. It was kind of just breaking up, but is the microphone in that white box in front of you? Is that where it's located? Because maybe that'll.
I don't know that.
I think it might be on, actually.
Okay, so it's not, we're not quite picking you up very well, so that may be a problem. We'll proceed, but we may need to adjust that. I think maybe if someone speaks over each other, it definitely got confused there. So if one person's speaking at a time and just kind of, pace your voice, I think it should be okay. I think it's just got to learn. We'll see. All right.
Can I just ask who's on that screen?
Yeah.
The two attorneys you were just talking to?
Yep.
Sure.
Because
This is
I can't see your face close enough, so otherwise I would know.
David Zappa with Hush Blackwell.
Thank you.
And Andrew Carden with WPL.
Got it.
Okay, so we just have one more person coming in here. All right, well, just let person with the screen name of A096263 on the Zoom. And I just want to know if you're connected with a party. Because this Zoom session is for parties and commission staff only, and the public should be observing through the live stream. So if you could let me know if you're connected with a party, otherwise I'll need to let you go from Zoom. Okay, not hearing from you. All right. Okay. Just want to check the Zoom live stream, make sure it's going.
Are you able to pull people from the second screen and put them on the first? I don't know how you describe that, but the main people talking, put them all up at the top?
Yes.
Okay.
I don't know who. Yeah, let's do that.
If you don't want to do it now, I mean, it can wait.
No, that's fine. Guessing we're gonna have. I'm just gonna guess. I know we have the.
Well, I think it's all the people that are on camera now.
And
so
staff. And we'll put people in as needed. So I'm just pinning everyone to the screen, but I'll add those pins as we need people to talk. Okay, I think we're ready to go. So let's get on the record. Welcome everyone to Docket 6680 TE115, the application of Wisconsin Power and Light for approval of an individual contract rate service agreement for a large load customer in Beaver Dam, Dodge County, Wisconsin. I'm getting better at saying all of that. My name is Michael Newmark, Administrative Law Judge for the PSC. We are at the party hearing session here on Zoom. So we have parties and commission staff connected. We heard public comments on Tuesday, the 24th, with 2 public sessions. And at this point, we're taking public comments up until Tuesday, March 3rd, either through the Commission's internet website or by U.S. mail. Just wanted to, for people listening in, wanted to let you know, we need to get those comments in the office by March 3rd. At least so far at this point, that the deadline's March 3rd, and or you can mail. So either send those through the link or mail them to us. We can talk about that deadline a little bit later, but and we're asking the public, in terms of observing the party hearing session, we're asking them to do that on our YouTube live stream. Link is here, and documents in the case available through this link here on the notice. So yeah, that's pretty good. So at this point, I want to get appearances, and I know we have some sort of an unusual circumstance in this case, but let's do appearances first. Let me get our, so the plan would be to take appearances and then go into closed session to discuss some issues about the confidential filings, but let's get our appearances first. And for whatever reason, I don't have my service list in front of me, so hang on. Here we go. All right, great. So service list. So let's take appearances in order here. Who is representing Citizens Utility Board?
Good morning, Daniel Narvi for the Citizens Utility Board.
Great, okay. And Clean Wisconsin.
Morning, Judge Newmark, Brett Cordy on behalf of Clean Wisconsin. I have a correction to the service list. Do you want that now?
Yeah, let's do that.
It just excludes our legal fellow, Liam Pembroke,
Okay.
who's on the IRF Excel sheet, but not here.
Okay. So that it's, so you're just, okay, this list may be out of date, but if the internal list is correct, I'll make
Yes.
sure the court reporter gets that information. So thanks for bringing that up.
Thank you.
Okay, and the PSC?
Sophia Rogers for the PSC, and with me is my colleague Manuel Sanchez Moijano.
Wisconsin Industrial Energy Group.
Yes, good morning, Your Honor. Steve Heinzen for the Wisconsin Industrial Energy Group.
Thanks. And Wisconsin Power and Light.
Good morning, Judge. David Zappo from Hush Blackwell for WPL.
Okay.
And with me is Andrew Carden from WPL as well.
Okay, great, thanks. All right, so we have everything here. Excellent. Okay, so before we go into closed, I just want to explain while we're in public session that I did indicate on the offered evidence list, which I also don't have in front of me yet, that I did have some questions and I wanted to review the company's confidential filings and the extent of the redactions that we see at this point. So there we go. So the offered evidence list here, just wanted to give people notice of that before we got here today. And what did I say here? Okay. Yeah. So, so you may be maybe have gotten a little confused about what I said here because I used the word overreactions instead of overredactions, but I think that the message was probably clear in substance. So we have a lot of redacted information in this case, including, just basic concepts about what's at issue here. And I think what came to mind to me was that looking at the commission's process, of course, being a state agency subject to public records law, and also just the state policy that the state that we do want to keep our records open for public inspection and to be able to scrutinize the commission's decisions, so the public has that opportunity to scrutinize our decisions and our decision-making process. It seemed like the redactions were not going to allow us to do sort of the basic functions of open government in that sense. So I know that the filings were were offered by by Wisconsin Power and Light, the confidential handling, and they were filed under a confidential handling request as our rules require. I also know that commission staff approved those requests, but as they come to me as being offered for the record, I think I need to review that in order to make sure that we're giving the commission a record that they can make use of when they make their decision, and also one that can be defensible in court and in the court of public opinion when when that decision is made. So there's some concern about just having the way the original filings, the application was filed, and the extent of redactions there bleeds into how the testimony is presented, and then will also then affect how the commission can discuss the case in open meeting, and then how the final decision gets written. Commission's been careful in the past to try to put some parameters around making sure that there is enough information so that the discussion and the decisions that the commission makes is done in a public forum and is open to public inspection. We of course have been always cognizant of the standards for holding documents and redacting documents from public inspection, at least in terms of our processing and for doing the going through the process of proceeding through a contested case. However, those decisions don't actually, they're not open records decisions. They're not decisions that would deny someone an open records request on its face. It doesn't preclude someone from asking for those documents in an open records request. But just in terms of our processing, records retention process, we go through this applying these standards to make sure that we don't disclose information that shouldn't be disclosed, that may violate other statutes or harm utility customers, but it's also not a final decision on whether these documents are open to public inspection. It's just in terms of our internal handling of a case. So, but as we sit here today, I think the way we're handling the case right now leads us to question whether there have been over redactions. And also, I want to note that certainly want to be cognizant and wanted to indicate that this is a case where the public is very interested in this decision and in the process, and I recognize that although there are standards and there are regulations in terms of what information needs to be protected from public inspection. The public comments we received in this case indicate to me that there's a great interest in getting more detail in the case. I think it's fair that the public understand at least more details in the case, and hopefully we can come to an agreement here as to what can be unredacted here, what information is redacted that can be released to the public at this point in order to facilitate greater understanding of what's going on and ultimately what the commission would decide if when it goes to deliberate and order some make decisions in this proceeding. So with that, I think we want to just go into closed session and discuss the documents, and we can get a full vetting of that. So the process we'll take now is we'll go into closed, we'll discuss the redactions and what to do about them, and then I think if it's necessary that we're going to see new filings in the case, I think it would be useful to have, we'll see how it goes, but I think it may be necessary to have those documents before us to proceed with the proceeding for cross-examination purposes and for purposes of displaying those documents on Zoom and on the live stream if possible. So we'll need to, so once we get it closed, I expect we'll break and then have new documents shared. I think the best way to do that would be to share it with the service list and myself by email, and then those documents will then be subject to filing once we're done with the hearing. So
Your Honor, I'm sorry, I don't mean to interrupt, but I was just hoping if maybe before we go in closed session, just we could be heard on this just overall process, because we do have some concerns that
the process
we just want
itself.
Yeah, the process that you just laid out and described on the offered evidence list here. I thought we just wanted to make some comments on that now before we get into closed session, if that's all right with you.
Sure, that's fine.
Okay. So I guess I'll just start by saying, Attorney, we saw obviously the notes on the offered evidence list. Attorney Rogers and I spoke about this yesterday, so we are generally aware of what you're proposing here, but we do have pretty significant concerns about revisiting the confidentiality issues, in this manner. From our perspective, and we certainly appreciate and understand your concerns about transparency and open governance and making sure the commission can, adjudicate this in a public way. But from our perspective, we're really here today to admit the pre-filed evidence and, give parties the opportunity to cross-examine witnesses. And we think revisiting these confidentiality issues now and in this manner is not the most efficient way to go about this. We would propose that essentially we defer discussion or resolution of these confidentiality issues until after the hearing, and I'll explain why. As you know, and as you acknowledged, we filed our application, we filed our direct testimony, months ago. We made requests for confidential handling, commission staff granted those, and there have been times throughout the proceeding where commission staff has had questions or concerns about our redactions, and we've engaged with them in good faith and provided additional information, and where appropriate, refiled the documents. But it now looks like there's a desire to sort of revisit those prior decisions, and we just don't think that this is the appropriate time or forum to do that. We're not clear on the exact nature or extent of the changes that are going to be requested, but as you just said, it sounds like the idea is we'll go into confidential session, review and discuss them, take a recess to, revise the redactions and then resubmit. I guess it sounds like over email. But we just don't think it's feasible to do that today. And I think there are maybe even some legal issues with that approach. I mean, on the one hand, we've had, less than 24 hours notice of sort of the idea to revisit these issues. Like I said, we don't have a specific understanding yet of what the issues are. I'd also note we're not the only ones who have a say over whether the confidential information here gets released. Some of this information is the customer's information, and we do have certain obligations to the customer with respect to that information under the ESA that could, present, I'll say, compliance issues with the ESA if it's sort of released without notice to them. And I'd also note that, under PSC code 2.12, 196, 135, 4A, if the idea here is to essentially change or retroactively deny previously approved requests for confidential handling, I think there's a waiting period on that of 12 or 14 days. And so just given all that, we don't think it's appropriate to try and resolve all these issues here today at the technical hearing. I understand it's a unique case. There is a lot of confidential information at issue. So this is maybe a one-off thing, but I think this procedure from our perspective is just highly irregular. And I want to be clear that we don't have any objection to working with commission staff, I think, as we have on several occasions throughout this case, to discuss and address legitimate confidentiality concerns. We share an interest in open government. These redactions are not coming from a place of we're trying to be secretive. They're coming from a place of, if we have another deal like this in the future, we want to make sure that we get our customers the best deal. And we also want to make sure that we're protecting the customer's information. So we're not opposed to revisiting or discussing these issues. We just don't think that this is the correct venue to do that. And so what we would propose is basically this for your consideration. The substance of the pre-filed written evidence is not going to change, whether there's redactions or not. The information is going to stay the same, whether it's subject to confidential handling or not. So our idea would be receive the pre-filed written evidence, subject to potential changes in the redactions, and then we can proceed with the hearing as usual. And if we need to go into confidential session, we can do that. If it later turns out that some of the items discussed in that confidential session, the confidentiality designation changes due to subsequent discussions with staff, we can release that portion of the transcript publicly. But the idea would be enter everything into the record now, proceed with the hearing. After the hearing, we can work with staff to discuss and attempt to resolve these issues. We just think this will allow the hearing to proceed more efficiently, preserve our rights and ensure that these issues are resolved in a timely manner. So that's basically it. I appreciate you letting us be heard on that.
Okay. Yeah, thanks. So I was trying to track the citation that you gave, and I think it was to PSC 2.12, but then there was other numbers, and I wasn't sure if I caught it all.
Yes, Your Honor. That was 196.135 of the Wisconsin statutes, sub 4A.
Okay, so you're citing statute as well. Okay.
Yes. And then 2.12.
Yeah.
I don't have this.
That's okay.
Pin.
I'm sorry.
So-
And then 2.12, I didn't hear what you said after that.
I don't have the specific pin site.
Thank you.
Sorry. So just so we're clear, my process that I would envision is that it would not be a rejection of the current decision that we have on file, accepting the current documents, but it would be in order for Power and Light to refile, so on a new set of documents. So to the extent that there's a difference there, just procedurally, it would be a new document. So I don't know if that helps, but any decision I make, of course, can be appealed to the commission. So we can also accommodate that as part of this process. But I think what's important to me is that in terms of the open, I think what part of this problem was involved in taking the procedure we're taking here is that we conduct the hearing in public as much as possible. So So that would require we make a decision on what's public and what's not before we proceed. But I can take comments on attorney. Your name's not there. Sorry. Zappo, yes. And I was going to pronounce it wrong anyway, you know. So Zappo's proposal, I can hear other comments on that. So if the interveners want to comment, go ahead.
Judge, I'll just speak on behalf of the consumer advocate. We share your overall concerns about the extent of redactions here, and well, we didn't object to the redactions at the time we were made. You know, we always have to weigh, you know, our level of resources and the time it would take and interrupt the proceeding when we decide whether to dispute things like that. We didn't do so here, so we don't have any specific you know, items that we're gonna argue should be unredacted. But you know, in general, it has hampered the ability of the public to engage with the docket. I've seen comments filed in public comments and in the media from people saying, well, we have concerns about this, but we don't know how to articulate them because the information's redacted. And it's hampered our ability to collaborate with other stakeholders that we engage with when communicating about the particular issues in the docket. So just kind of to set the table generally. I do think it's appropriate for you to sort of sua sponte consider these issues, even if interveners aren't objecting and staff has permitted things to be filed publicly, or sorry, to be filed under seal. That said, I don't have an objection to what Attorney Zappo has proposed. I don't know that we need to address the redactions at this point. Partly that's because I don't know that during today's hearing that we're going to go in depth on a lot of redacted items that would, you know, inhibit the public's ability to see the docket. I think if that were the case, that would be a reason to resolve this today so that everything could be, you know, if there are cross-examination on issues, that those could be available publicly, but I'm not sure that's going to be the case. It's not. I don't anticipate CUB having cross-examination on those issues. Yeah, don't object to what Attorney Zappo has proposed. Also, don't have an objection to the process that you have laid out.
All right.
Thanks.
How about Clean Wisconsin? Any comment there?
Thank you, Your Honor. We agree with everything that Attorney Narvi said on behalf of CUB as far as you know, the problems that the confidential information in this docket has caused throughout the proceeding. Likewise, Clean Wisconsin did not challenge those decisions early on, and I would just echo the, you know, limited resources and capacity we have to make choices all the time on, you know, whether we challenge something like that or, you know, try to compel discovery. Like, those decisions are just part of our, you know, work in front of the commission every case that we're in. I would say that just on a practical matter, we were not expecting to have to roll over into tomorrow, and I think our witness has very limited availability tomorrow to make that happen. And I would also say that, like CUB, Clean Wisconsin does not intend to go into anything in cross-examination that would require closed session at this point. Thank you.
Yeah, thanks. So I did have in the pre-hearing conference memo that we were reserving Friday, but I understand I take notice of your concern about timing. How about Weig?
Yes, Your Honor. Weig is fine, certainly with the process that you're suggesting, but we're also fine with what Mr. Zappo is suggesting with this as well.
Okay. So before I ask commission staff, I just wanted to verify. So I guess my concern with Attorney Zappo's proposal is that I'm not sure. I would like to have the debate about what's confidential and what's not before me, and in this forum, I suppose, rather than some sort of off the record paper process or negotiation with commission staff. I mean, my understanding is that staff and the applicant have been in negotiations about this, and this is the situation we're in. I don't know if my concerns were conveyed until now, but but having said that, I guess the problem is, at what point do we come to a decision, and how do we, if this is between staff and the applicant, which it sounds like mostly that's where the concerns are focused. If there is no agreement, how do we come to an agreement? If we proceed forward and I accept the current filings subject to an agreement on what can be made public in addition to what already is. If there's no agreement, then what's the solution to resolving this?
So
go ahead.
Oh, I'm sorry, Judge. I didn't mean to cut you off.
You're good. Go ahead.
So I guess I'll try and take kind of those things in turn, to the extent that certainly understand, like, if you have concerns or questions that you want addressed, I could certainly understand that. I guess I think that could maybe be achieved through some kind of written order, some kind of written process, just because I think it's going to be more efficient for us, to the extent you're looking for further justification or context, to do that in writing. And so it could be in the form of some kind of order and motion practice, show cause order of some kind. And to the point on, well, if there's not agreement, I see your point. I think there, that's kind of covered by PSC 2.12. If you or commission staff don't think that something is entitled to confidential treatment, you can reject the request for confidential handling, and then we have a procedure we can go through after that. And just the other thing I'll note too, in response to some of the concerns that were raised by the interveners, is that the parties as it is now have access to all the information. Everyone's executed an NDA. I understand your concern about the public access, but I just wanted to clarify that for purposes of this hearing here today, I think everyone has access to what they need, to the extent that they want to ask questions on some of these maybe more commercially sensitive topics.
Mm-hmm. Okay. All right. So does commission staff have a comment?
Yes, Your Honor. First, I'll just address the sort of elephant in the room. That staff did accept the application redactions, and really looking back at how the record has shaped up and all of the issues that have become prominently discussed and really will require being addressed by the commission. It's abundantly clear at this point, looking back, that those redactions were overdone and are hampering the process here. So, at the time that we received the initial application, staff, as everyone has said, staff time has been very scarce, and we weren't familiar yet with what would be or become the key terms of the contract. This is a completely new form for us, and so we failed to recognize just how over redacted the application really was. Looking back with the benefit of hindsight and the full development of the record, it's abundantly clear that we need to resolve these issues, and I think doing so in this forum is absolutely necessary, and we should do it today. In fact, I regret not raising this at the pre-hearing conference when we all convened and could have resolved some issues before going into testimony and then facing all these challenges logistically and administratively in dealing with all of these redactions. My colleague, Attorney Narvi, commented that there might not be a lot of cross today. I am aware of at least 2 questions that are requiring going into closed session. And so there is a direct benefit to resolving the issues before having to go into closed session, or I should say going into closed session to resolve the issues before then going into that cross-examination. Staff is prepared today with a list of all of the terms that have come to the top of our we can it's clear when reviewing the testimony and looking at the redactions and testimony from staff and the interveners what are the topics that really are in need of clear discussion, but we're prepared with that list. We've reviewed the trade secrets and customer information standards, and we're evaluating the terms in a new light against those. We appreciate that, we can't go back and undo the confidential handling request without additional process, but you, as the administrative law judge, absolutely have the power to order additional filings. And we agree that it's necessary to see those. We were hopeful after all of our conversations with attorneys for the applicant that they would come in with some prepared with some concessions on what could be unredacted. There's a lot here to work with, and some of them are pretty easy. I'm hoping that we have a good conversation when we go into closed session, but we forcefully object to delaying this conversation any further. We regret that it's happening so late as it is, and think we need to resolve and the issue before anything is accepted in the record. I think it's a very slippery slope if we just go back to the paper or informal discussions. I think we need to talk.
Judge, if I could just respond on a couple points, Judge.
Sure. Go ahead.
I think so. I want to emphasize what I had mentioned earlier, which is not all of this.
Hang on, just let me. I understand what you said earlier. So if you have anything additional to add, go ahead.
I'll just add that if there's an order or a requirement to refile now, removing redactions over information that we think needs to be maintained confidential, and more importantly, that our customer thinks needs to be maintained confidential, we don't really have a remedy to deal with that. We could potentially face irreparable harm. The customer could face irreparable harm if it is disclosed now. So I just don't think this is it's not an efficient way to deal with this, and there's also a legitimate chance of harm from these disclosures.
Mm-hmm. Okay. Well, I think the devil's in the details here. So I would like to have that discussion with you guys, and we can then decide how to proceed. And if, like I said, if we can come to an agreement on what more information can be unredacted, that would be the best way to proceed. But I think the best way to find out is to actually have that discussion. So to the extent we can do that and we can resolve the question, I think we should do that now. To the extent that there's disputes and possibly other ramifications in terms of the procedures for releasing the information to the public, we'll have to take it as it comes and provide the opportunity for you to exercise those rights. But that may include, delaying the process. So I think we should all recognize that and be open about it.
Your Honor?
Yeah, go ahead.
Sure, thanks. Before we go into closed session, would it be possible? Oh, you know what I'm going to ask right now.
I think so, but go ahead. Yeah.
Yes, if we could walk through who will be crossing, who will not. Thank you.
Yeah, I think that's fair. So as long as, and we can, what I'm assuming you're asking is that if we can excuse some witnesses who don't have any cross and they can be free of this debacle, I agree that is appropriate. But I just want to make sure the attorneys for the parties know that if we do come up with a new set of criteria for releasing information, that it's the attorneys that, if the witnesses isn't around, then the attorney will just be agreeing to that without the witness present. So don't think that is a big deal there, but I just want to make sure we don't run into any issues with that. Let's hear. So I think power and light witnesses, there's cross for them. So let's just go down the road, down the list here. Do we have any at this point, as we sit here today, any questions for Cub witnesses? Adams first? No? Okay. Keim? Or Singletary? Nothing for them? Okay, so we can accept their testimony by affidavit. They don't need to appear. So, let me just note, I know that Commissioner Hawkins was on the line. I just want to make sure if he had no questions for witnesses. I don't think he's there.
I don't for the Cub witnesses, Your Honor.
Okay, thanks. Just want to check in with you. All right, and for clean Wisconsin witness Jester, any cross for that witness? No? All right, so we can excuse Jester with affidavit. And for weak witness Pollock, any questions? All right, we can excuse that witness too. So before we move to close then, before we release them completely, let's just go off the record to see if there are any issues with the offered evidence list for those witnesses. So off the record, let me just ask Cub if we have any issues about the offered evidence list, the comments.
I do have some questions. I think it'd be good to have clarified.
Sure.
If we can walk through those.
All right, I'm ready.
Okay, so the first one is with Dr. Keim's surrebuttal. I think the issue is that his first exhibit was also an exhibit filed by Mr. Singletary. So I think the surrebuttal should be refiled with that reference changed and eliminating X Cub Keim 1.
Yes.
Okay.
Right. Forgot to do that. Yeah.
So turning to Mr. Singletary's exhibits, Exhibit 1, the comment has to do with containing no marks or alterations or filing a portion of the document. This exhibit is a 6-page rider that's in a tariff sheet for MG&E. It is the full document for that rider, but obviously it's only a portion of their tariff sheet. So I'm wondering what your direction is for that one.
Yeah, if we could just include the tariff sheet, the cover page of the tariff.
Oh, just the cover page?
Yeah,
for the tariff. Okay.
Right, because we're looking at I don't know where my comments went here, but yeah, we're looking at making sure we have, if you're filing a excerpt of a full document, you want to put that title page on as the first page of your exhibit.
Okay, that makes sense. Exhibit 2 is the set of discovery responses.
Mm-hmm. Yeah.
And your question was, were there attachments cited here filed on IRF?
Yeah.
And this also ties into your comment on Exhibit 4, potentially.
Right.
Exhibit 4 is an attachment. So we can handle it however you want. If you want us to file all of the attachments for 2 or just that one?
No, I was just curious. I couldn't find that attachment on IRF, so I just was wondering if that was filed, and that might be a question for the applicant.
Oh, okay.
But aside from that, there's also, okay, hang on. So there's also numbers 4 and 5, which is to make sure that you're using the version. Yeah, so that one worked. So Singletary 2, you use the version on IRF. That was so you can see the IRF stamp. But on, I think 4 and 5, they don't have that stamp. So that was part of the problem with those. So I think the first thing was to look at whether so what this is 2. Oh yeah, and then you notice the numbering is wrong, right, on the exhibits. Let's see this now. So I'm not seeing that now. Which one is that? Singletary 2. Oh. Can't get to that. So it's 2 Cub DR9. And there's some reference to attachments and
So, Judge, I think I can speak to that if it would be helpful.
okay, yeah, here it is.
Yeah.
Go ahead, please.
Yeah, so this was, right, this was just a request for, standard, give us your work papers and documents you relied upon. So anything, for responding to the previous interrogatory, so anything that is responsive to this request would have been produced in response to the preceding interrogatories, basically, if that makes sense.
Okay.
So there's no unique documents that we would have filed directly in response to this request. They would have been filed in response to the other prior interrogatories.
Okay. So it doesn't, okay. Okay, does it say that there, or am I just, because it is producing documents?
Yeah, as attachments to the foregoing interrogatories.
Okay, great. All right, thank you.
No problem.
Got it. All right, thanks. So I'm sorry, let's get back to Cub. Any other issues with the comments then? We're on Singletary 2.
Yeah, just well, on for Singletary 4, that is there's not a there is a that
So
attachment
this
is filed in IRF.
Oh, yeah, and is this an
It's-
Excel, from an Excel file? I mean, there's no PSC reference number. That's the problem with this one.
Yeah,
It's from an Excel file.
yes, I
Okay.
believe so.
All right, that's a problem. Okay, and the same thing with 6. Looked like the same, similar formatted document.
Let's see.
That's an exhibit in another case, so that should have a filing. So you should have a cover page for that, a first page for the.
Okay, so
Has some
6 should have a cover page. We can correct that.
Okay.
Oh, sorry. I think that the cover page is
Oh, you're
there.
right. You got it. Okay, excellent.
Okay, so that one's good.
That one's good. Yep.
Let's see, there's a comment on 5. Just go back real quick.
Oh, 5, I think we were. 5 is okay.
5 is similar to 6. So there is a cover page,
There is. Okay. All right. That's fine.
so that one's good.
Yes.
Um,
Yep.
And then for 7 and 8, I think these are both commission documents filed in other cases. I think you just wanted us to put the
Just
footer that says no,
Yep.
no, not record evidence,
Yep.
et cetera. So, okay, I think we have direction on those ones. Okay,
Excellent. Great.
that's it for Cub then. Thank you.
Okay. How about clean? Any questions on those comments?
Your comments make sense to me, Your Honor. I would note that in the same vein as exhibits 2, 5, and 6, CW Jester 3 is also from that same Singletary 2,
Okay. Yeah.
also included. And then my only question is whether in the exhibit list in the refiled testimony, if we just remove those exhibits and just have exhibit 1 and 4.
Mm-hmm. Yeah, or you can
Okay.
just strike through it.
Okay.
That should
Thank
be
you.
fine. Yeah. And I understand you didn't know they were going to be filed, but this way we're not looking for, we don't get confused as to what we're looking at because it's the same document. And I think one of them at least was the public only version, and this way we have the confidential. Cub filed both versions, confidential and public, so that just gives everyone the full picture.
Yeah.
Okay.
Makes good sense to me. Thank you, Your
All
Honor.
right, appreciate that. So how about Week? Any questions?
Thank you, Your Honor. I understand your instructions, so I think we're good to go.
Okay,
Thanks.
excellent. So I kind of put everything on the bottom. It's probably not as conducive as putting these explanations in the comments. It was just a lot easier. But I think these are the things that keep coming up over and over again. So maybe use this as a kind of a checklist when you're filing again, just for everyone to know. All right, so that's all we need for that. So we'll just expect those refilings and the, well, let's see. I guess let's hold off on refiling until we know if there's any new information that needs to be filed unredacted. But we'll try to remember to give you instructions about that.
Your Honor, Commission staff had a couple questions and also noted that there was a comment at the bottom of this page that appeared to be for witness Pollock. It might have been moved in your version.
Yeah, it was.
Okay.
But staff's going to be so I'm just excusing witnesses now, taking the information on the offered evidence list for witnesses we're excusing.
Okay.
And so staff's going to be coming, we're going to be calling staff right during the course of the.
That's right. But we had a
yeah.
question on one of the exhibits that it needed to be refiled.
Okay, well, what is it then?
It was for Lincoln Miller, exhibit PSC Miller 3. You noted refile to comply with number 7. I think the issue was actually that there was no cover page. No title page.
Oh, okay.
And so we will correct that.
Yeah.
Then for witness Shield exhibit PSC Shield 1, you said refile to comply with number 4, and I didn't understand that one.
Oh, I think it doesn't have the IRF stamp on it. So there should be a version of this on IRF. Or maybe there isn't anymore. I think I saw it. So if we have a version on IRF, on the publicly accessible IRF, then you'd want to use that. But maybe we don't. I guess I didn't.
Yeah, I didn't think that we did. If Jolene, witness Sheila is on right now, maybe she can clarify.
Well,
I didn't.
That's okay. Well, when she takes, she'll be taking the stand.
Yes.
Okay, we'll deal with it then.
Okay, sounds good. Thank you.
All right. All right, so I think that's all we have for offered evidence list. And like I said, remind me to instruct everyone about refiling when we get to it. When we've made some decisions about what's coming in, what needs to be refiled in terms of confidential and public. All right, so at this point we can go into closed. So I'm going to, I don't know if people can see the participant list. To me, it looks like we have parties and staff only connected. So that looks like everyone could be, oh, and we have a new attorney coming in here for Power and Light. Looks like we could be putting everyone in the closed session breakout room. So this shouldn't be too tricky. We should be able to move you guys over pretty quickly. So I just wanted to confirm. So we have Tricia Smith. We can go off the record. I think we are off the record. Right?
We are.
Tricia Smith joined us, but screen name indicated that Attorney Smith's representing Power and Light, and I think I want to make sure we all know that.
That's correct.
Yeah. And so I'll move everyone to the breakout room, and we'll start the confidential. So people watching, we do have about 53 people on the live stream. You will see a note that we're in closed session, should not hear or see anything. That's just going to remain up like that until we go into public. We'll do that. If we do take a recess, we'll go into public first. So I'll let you know we're in a recess. And when we reconvene, we'll be sort of up in the air, I think, because if we need to spend time correcting some documents, we'll need to, we can communicate through email as to when we're going to reconvene between the parties and staff. But I guess just sit close to the live stream, sit close to YouTube, and see if you can, if you catch us coming back in the public session. So yeah, let's move into closed.
I can't tell if you're talking, but you're muted. Judge.
I just said everyone's muted. That's what I just said. So yeah, that was pretty crazy. All right, so everyone was muted, but at this point, we're back in a public session. We've had some discussion about the documentation and its redacted public versions of those. We're going to go into recess until 1 p.m. We'll hear back with the utility getting further perspective from its side on this debate, and we will reconvene, start in public, and then go back to confidential. So thanks, everyone. We'll be in recess until 1. That's the problem. Okay, an extra button for me. All right, so we're back on the record in public session. Now I can do this all over again in a much better way. So we're here back after our confidential discussion, and I think we're looking to the extent we can get a response from the applicant now after reviewing what staff have proposed. So we'll start in public and we'll go into closed if we need to. Go ahead.
Thanks, Judge. Yeah, so we did have an opportunity to confer internally, and I think we didn't, until yesterday realize that this is such a significant issue for staff. So we have a proposal, which is that I think, while we don't have a complete understanding of staff's concerns, I think we have a general understanding of the sections of the agreement that they're asking to be unredacted. And so we would endeavor in good faith, basically, to work with our customer to remove basically as many redactions as possible from those sections of the agreement that we discussed during the closed session. Again, like I said at the beginning of this, we do need to confer with our customer on some of that. We've already been in contact with their representatives, but we need a little time. So what we could do is basically commit to having an updated version of the ESA refiled with, again, the redactions removed by close of business tomorrow, on the condition that we can proceed today with the rest of the technical hearing, and the understanding that if we need to go into closed session for any of the cross-examination, and that information that is discussed during closed session is later, made public through our subsequent filings, Your Honor can release that transcript from the closed session publicly. And, we're aware that I think that's been done previously in some rate cases. So that's basically our proposal is, we'll commit to work in good faith, again, to unredact as much as we can from that agreement, submit the filing by close of business tomorrow, provided we can basically get the hearing done today.
Okay, well, let me just make sure, I just want to clarify one thing. In terms of Wisconsin PSC, Wisconsin Admin Code PSC 2, close of business is 4 p.m. You guys should know that, but I just want to make sure we all agree. Yeah. So, hang on, I just got left someone in here. So, do we have and I'm not making a decision about anything else, just wanted to make sure you're aware of that. So, any response from interveners or staff?
No objection from Cub on that process.
I was going to say the same for Weeg, no objection.
Sorry, I'll let other interveners speak.
Yeah, I think we just have clean.
Your Honor, I don't object. I would note that I'll have questions about refiling revised exhibits and what's expected of the interveners if things change as far as what's confidential. So as long as we can figure that out.
Yeah, so like I said before, we're gonna put that in abeyance, the refiling deadlines, because we don't know what the final versions are going to look like based on what needs to be, what can be released that's been redacted so far in the offered evidence and exhibits, and what needs to remain confidential. So let me say that for now, we'll hold the refiling deadlines in abeyance. We'll have to sort that out. But the corrections we've already talked about, of course, are still applicable. But
Your Honor.
And go ahead. Yeah. Anything else, Attorney Cordy?
Yeah, just on that point. So would we refile based on the offered evidence list corrections and then refile again if,
Yep.
okay, so we'll
Yep.
hold all of them in abeyance until the confidentiality is sorted out. Okay.
Yep. Yeah, the deadline to file is in abeyance. Yeah. Okay.
And I'm sorry, just a very quick follow-up. And so I would imagine then the deadline for filing affidavits supporting testimony is in abeyance as well, or maybe not, because some of that will depend on refiled exhibits, for instance.
I don't really have too much of a concern about that. But if you want to, yeah, we'll just make all those post-hearing deadlines, put those in abeyance. Probably the briefs too, I would guess, depending on how we well, let's leave that for now. We don't know what we're doing yet, but all the so the offered evidence deadlines, post-hearing deadlines, we'll put those in abeyance until we know what we're doing with the redactions. So that would be the witness affidavits, the corrected testimony, and the other one, which is the revised exhibits, right? Well, those I don't think we have any. Yeah. Okay. Well, yeah. So all those three are just we'll just set a new date based on what happens. Anything else from interveners? Okay, go ahead, Attorney Rogers.
Thank you, Your Honor. Commission staff, I think, would have been able to. So initially, we had discussed the possibility of reaching some kind of consensus today, and then having the applicant refile. And I think we, depending, on the outcome there, I think it would have been workable for us to proceed that way. Right now, I have no idea what the applicant is offering to revise, and so I'm not comfortable proceeding. Staff has an obligation, and it's gonna, very seriously go through the refiling for confidential handling a lot more closely this time. I think we need to see justification on a totally different level than what we saw before, and we can talk about that. And what might be helpful there, I think, is a log, providing reasoning, not unlike what you do in the received evidence list, but to say, here's the reasoning that applies to this redaction, this redaction, this redaction. So just the going through and understanding what the revised application is going to contain, that's going to take significant review and a better review than what we did last time. And so I don't know how long it'll take. We have 30 days to review confidential handling determinations, but obviously, we want to keep this moving, and we've already had opportunity to look at this, of course. So I don't think that the timeline the applicant proposes makes sense at this juncture without, knowing the scope of the changes that are going to be made. If we can get some kind of idea of what whether those terms that I identified, what we're looking at, like if I were to hear, okay, we can come almost all the way. Of course, that wouldn't take long for us to review, but I'm not hearing any indication at all of what we'll have to deal with. It could be that we keep going back and forth on this, and we have to deny the filing, and then where does that leave us? So I'm not sure I have a proposal at this time. I'd like to see the filing promptly, but I don't want to be held to a record that's created even before we have opportunity to get that filing nailed down.
Okay, so I want to point out that the commission can't make a decision based on a document that's being considered for confidentiality treatment under PSC 2.12. So, to the extent that something gets filed, determination is going to need to be made before we can give the record to the commission. So, a determination on confidentiality will need to be made before the commission can I don't know if we can, I suppose it's probably best not to give it to them, but I guess they can't make a decision based on it unless there's a determination made. So that's one issue. But the other one, I guess, is just, I mean, I guess so in that sense, proceeding with the company's proposal would still preserve the commission staff's ability to, argue against those redactions and seek some new redactions. So, but before the record is closed, so to speak. But I think it might be helpful if the applicant could give us some more of a roadmap as to what seems to be acceptable in terms of the concepts here, or what is there any representations you can make now about to the extent of what the new redactions will look like, or are you totally on a new page here that you'll need to discuss and start over?
Yes, I think we can speak to some of that. So I guess, and maybe first to the point about, the justification, we're more than willing to provide more granular or particularized justification for the redactions. I think that makes sense. And I don't know how much in the way of specifics I can offer, again, just without talking to the customer, but I can say we understand we have a list of all the terms that we talked about during closed session. And I can commit that there will be significant movement on releasing more of that information publicly. I would caveat that with, like specific numbers or pricing information, customer load information, which is, by statute, is exempt from disclosure. That kind of stuff is not going to be unredacted, but a significant portion of, again, I think the language and certainly the section headings in the sections that commission staff identified, we will again work to make significant movement on redacting that.
Okay, so just let me confirm with you, what's the statute that you're implying with respect to customer load?
196, 137.
Okay, municipal utility customer information.
Well,
Yeah.
yes, and I guess I can expand on that if you'd like, Your Honor.
Well, I guess I'll just flag that, and I guess we'll see your justifications based on that statute when you file. So, so I guess that's another issue. I guess you'll be filing this on IRF under a confidentiality request, and then I suppose I would think what we'd want to see, I think maybe slightly different than our normal process is, well, let's see. What do we think about having you file the justifications as well as a confidential and public? No, let me forget that. Just include it in the request. I think the way we normally do that's probably.
Well, Your Honor, it might, given the length of the document, it could be easier for everyone to have an attachment filed confidentially.
Yeah, I guess I'm just thinking we have to approve that document as well. It just seems like.
Well, there's a provision in the code allowing for additional information to be provided to justify a request, and so I'm envisioning maybe an Excel spreadsheet with page number and maybe the paragraph number or something, and then the out of a menu of arguments, like which argument applies.
Okay, so you can hide the text in that issue, but then just provide the justification. Is that what?
Yeah, I'm sorry, I don't want to interrupt.
No, go ahead.
I was just going to say, I don't, I think, and I don't recall specifically, but I think typically, I don't know that our justifications are typically filed under a request for confidential handling. So I don't know, it may be, but I don't expect that we will need the justification to be confidential. To commission staff's point, yeah, we can, if it's a table or an Excel spreadsheet or something, just that itemizes, by page or section and justification. Yeah, we can do that. Yeah.
Okay. Yeah, it just might be better to organize it. I think so. When you're filing on IRF, you'll have the form that goes as part of the filing, the web page form. You could just put for justification. I think it's section 5. Say see the accompanying spreadsheet or accompanying filing, and then file that separately. And this way, we'll have something else to refer to that can be better organized than what you see in that box on the form.
That makes sense.
Okay. So,
Your Honor.
Yeah.
I want to make sure it doesn't get lost. We had discussed, I think in close, but it's not, I'm not going to give any confidential information away here. There were redactions in the application in May that weren't maintained in direct. Several things were disclosed, and then more after commission staff made some requests to the applicant, which had voluntarily it made some corrections revealing the customer information, for example, the name of the customer, for example, and all of those things. So all of the things that were corrected from filing direct to the refiling, all of the things that were disclosed between direct and rebuttal, and anything else, that should also it should flow originally from the application, and it's never been, that application, it's never been updated for all those disclosures. So I just want to make sure that in addition to those terms, the specific rate components and other terms that we went through, I just want to make sure that the applicant understands and commits to the disclosures it's already made in other filings.
Let's hear from them. I think that's fair.
Yeah. So if I'm understanding correctly, the idea is any changes in the redactions on the ESA flow through to the application and its attachments. And I think, yes, we can, we can make sure that happens and gets filed concurrently with the updated agreement.
Actually, that's all good. But what I was actually saying was there have been some improvements made between direct and rebuttal. And after direct, there were corrections made, which we appreciated, to reveal things that were publicly available, like the customer name and some other things. So all of those disclosures we want to see reflected in the application filings, the ESA, and also the application narrative.
Okay, yeah, that's understood.
Okay.
Yeah.
Okay, and then, yeah, so everything that's unredacted so now I just want to be clear, Attorney Rogers, are you asking for that to be filed along with, so the framework is we're really looking at the energy service agreement to be filed with, with the redactions, that the new redactions or new disclosures that the company's proposing. So are you looking to have all the remaining documents be updated to reflect the company's new proposal?
Yeah.
At the same time?
Well, it doesn't have to be at the same time, but I mean, I'm not saying when it should be filed.
Okay, but I mean, we want to do the ESA first and then review that and then have the company update based on what ends up happening with the ESA, or do we want to have the entire set of filings refiled based on their version of what should be redacted?
Staff is open to what the applicant thinks makes sense here.
Start with.
Yeah, I think Can you just give me one moment?
Yeah, that's fine.
Okay, so I think what we would propose to do is, because the ESA is an attachment to the application, so we would update it and the remainder of the application at the same time by that deadline tomorrow.
Okay, and then the testimony and exhibits can be.
Right, and then the rest would flow through to testimony or exhibits or whatever, Well, once we have agreement with staff on that, on the changes that we make to the ESA.
That makes sense. I'm gonna just check in with staff on how long we might need. What was the proposal?
Let's go off the record.
Thank you.
Off the record for this. So the company's committing to file by 4 p.m. tomorrow, the updated ESA and now the application, the entire application. And then once, if staff was to approve that, then we would see the direct, the testimony and other exhibits coming in from the applicant as revisions would be necessary to reflect the new updated application.
Yeah, I think.
Yeah, go ahead.
Yeah, I think, Your Honor, that summarizes it. I think we think that's probably the most efficient way to do it, just in case staff has other changes or issues. But we're if staff wants to do it another way, we're open to that too. Mm-hmm. This just seems like the most efficient way.
We appreciate that. My only concern here is, giving staff enough time to do a good job in reviewing the filing. So it's a long document. The ESA itself is long, and then we've got the application.
So we're not setting a deadline for staff.
Well, I think we might have to talk about a deadline because we have briefing coming in on the 9th.
Well,
I mean, if there's no deadline, that's great. But I think,
I don't have I don't think there's, we're holding everything else in abeyance.
Okay. I thought that was just for the record.
Well, it is. That's all I can control, but I don't know what the commission's going to review if there's no record. So,
okay. I think the commission staff absolutely will do its review in under 30 days, much less than 30 days. But I just don't want to limit it to too short of a time period. So I guess if we can take some time to process the refiling, make sure that we're absolutely comfortable, that would be fantastic. And then I don't know how the rest of the schedule will be decided, but we can cross that bridge when we get to it.
Yeah, I think, let's...
the only thing I'd add to that is just in terms of the briefing, the substance, the substance of the record isn't going to change. It's just going to be what's public. So I don't know that the briefing deadline has to move. But I just wanted to remote,
Yeah, that's fair. That's a good point. So, yeah, I agree with that. And to the extent we may need to refile something just to bring things up to speed for redaction purposes, that's okay too. If people want to brief based on what's been filed, that's fine. So, bring this
That's great. We appreciate that. Assuming the interveners are okay with it, we don't have to file a brief.
No objection.
Don't have an objection to keeping the briefing schedule. I guess
Yeah.
I'm more concerned about kind of the order of operations on the refilings, because having the, you know, application, the ESA done, my concern is that, you know, when we file testimony, it could either be based on, we're either, you know, citing the application sometimes, but sometimes citing WPL testimony. So, you know, is it incumbent on us to go in and figure that out, or are we going to see refiled testimony kind of in the order of the rounds to be able to refer back and work through it that way? I don't know.
In terms of understanding what you need to redact in your brief, you're saying?
No, for refiling testimony, I'm not concerned about the briefing timeline. If we need to, you know, refile briefs, that's fine.
Okay. Well, I mean, I wouldn't be too concerned about those corrections for the purposes of the substance of it. I guess I don't know when all that's going to happen, but we could. I mean, we already have, it's only the 26th. Why don't we just shoot for like, I mean, I think one thing, the way this can be handled is just through like motions that everyone kind of files with a stipulation that we're going to, you know, now that we know what we're doing, we all agree to update things on this date. Because we really don't know what the dates are at this point. So if we were able to proceed with that understanding, like nothing is due until I see a request to modify. Well, we've already held this in abeyance, so in terms of the post-hearing schedule, so we'll say nothing's due until I get a request to say, here's the new schedule, we all agree. And I don't think there's going to be any disagreement with that, but you know, assuming that we can agree on the filings themselves, the redactions. But so so let's see. So just so you know, we're off the record. Just want to push this out here. So if we kept the briefing deadlines the same, but then with that understanding, the briefs are the same. We would want to see the applicants direct the total of applicants' evidence filings coming in, and then give some time for interveners and staff to refile theirs based on what's been released by the applicant. I think if you guys want to work out a schedule that you can all agree on that would be fine. And I'll just wait for that, and we don't have to worry about refiling testimony corrections until we get to that date, or we get that agreement with those dates.
Yeah, Your Honor, I think that works. We're happy to coordinate that with the other parties once there's, consensus on our updated ESA and application filings.
Okay. So,
Your Honor, I have two questions. I think one is potentially for staff. Is staff contemplating going back through data request responses, staff data request responses for redactions?
Great question, Brett. And yes, we would need to do that.
Okay. And then for you, Judge Newmark, I think you alluded to it at the beginning, but we'd also be Clean Wisconsin would ask that the public comment be extended to accommodate for this if the whole point was to make information that should have been available to the public available. We propose that the public comment deadline be extended to allow for the public to use the new information available to it.
Okay, well, there's two things there. So I guess I was thinking, I think the discovery makes it a little more complicated. I wasn't really contemplating having the discovery all be updated, but just because of the administrative burden that would create. But I think if we could come up, so here's an idea. If we want to apply the new level of redactions to discovery responses, we just do the ones that are being offered for the record specifically, rather than going through them all. I don't know. I'm just trying to come up with something a little more, doable in terms of workload, because I don't know what the extent of the discovery responses are. But the ones that we're bringing to the commission's attention, at least, would need to get updated. I think that's, at least that there's not that many that I can see that were involved there. But what about you, Attorney Rogers? Any thoughts on that? Because I know, do we have a lot of data request responses that we'd be looking at, or?
We do, yeah, and we want to get those right and corrected.
You do, okay. So then, how do you propose we do that?
I think we start with the ESA and the application narrative. Get on the same page there. And then we can work out a schedule with the parties on what comes next, in order. It's going to be a lot of cleanup, but I think we can figure it out. I think we can probably update the DRR by filing replacements to the original data requests and having the applicant do it the same, updating the exhibit, revising the exhibit on IRF, so that everything appears as it should. And then, having that come out at the same time as the applicant direct, and maybe everyone's direct if we're all comfortable proceeding.
Right.
Or maybe the DRR and the applicant direct come out first, and then everybody else's testimony comes out after that. I'm not sure, but I think we can work that out with a little bit of thought, and not too much work. We really do want to get this into shape, and we don't want to be housing records that are not complying with our public records obligations.
Yeah, and Your Honor, we're, obviously the data request responses to staffs, that was we put those redactions in. So to Attorney Rogers' point, we can work with staff to refile whatever needs to be refiled based on the updated redactions. Probably, again, at the time we resubmit the pre-filed testimony.
And concurrently, we have redactions in the questions themselves that we'll have to correct. So I think we can probably do those all at the same time. And then I guess the exhibit itself with all the links will follow shortly after that.
That's not a big deal. Okay. All right. So then we'll take a step back and say, so basically we're going to redo pretty much everything. So that means we'll have so we have the date for the application, so tomorrow at 4, and then we'll have review of that, potentially approval from staff, and then we'll have an agreement that we'll need to see come in about the timing of the companies offered evidence and data requests and discovery responses. Then those will have to be reviewed by staff. I don't know, and then, but at some point.
Those should be fine.
Oh, well.
If they flow through from the.
If they, yes, you'd have to make sure, but yeah.
Yes.
Okay. That's what I was talking about, the burden.
I'm sorry, that'll be
Yeah.
faster once
Yeah,
we get.
okay.
Yep.
And then at that point, we'll have to have a deadline for the other remaining parties and staff filing their testimony and exhibits.
Mm-hmm.
And then, but we'll assume the briefing deadlines are the same.
Judge, how do you want the naming convention to work? We can.
I don't really have naming conventions for data requests, so I guess if you just want to attach a revised at the back of each name, that works.
Yeah, we can do that.
Okay. So just everybody note that. So, all right.
You're saying everything would just be revised. The testimony would just follow that normal convention.
Just, yeah, the data request, just add revised to the back of the name.
Okay.
I don't know, I mean, that's fine. And then, yeah, the testimony will just use the regular conventions for filing revised. And then parties can just include their all the corrections as well in that one refile of their testimony and exhibits. Then, oh, and so public comment period. So we were off the record, but I just want to make sure everyone knows that we can extend the public comment period because there's a fresh look at this. If the public wants to get it, that's fine. I don't really have any problem extending public comment periods unless staff has some issue with the timing in the case. But I guess I just want to say that's not the reason why we're doing this. The reason is because of what I said before, for the most part. In addition, we did see a lot of concern from the public, and I think, that's also, an element of this. But in terms of the public, having, let's just say, we can extend that date, but I wouldn't say that's the main reason for doing this. But, and I guess, I don't know, we don't really know when this stuff's going to happen. So I guess the same idea, if you want to include that in your request. I mean, I can let's just make it March 9th, and then I'll just have you guys change. I'll have staff change the deadline to March 9th for the comments.
Judge, what if the application redactions are still unacceptable at that point?
Then we can change it again, I guess.
Okay.
But I mean, that at least gives us a date to shoot for.
Okay.
So, any other comments about that? I can get it. Otherwise, I'll review this on the record, and I'll probably need a lot of help too. Let's get on the record. So we discussed the proposal of the applicant to attempt some updates on the redactions that we're talking about, making more information public in its filings. And let me first just review the schedule issues that we've come up with here for the record, so we have a chance to make sure we hear them and think about them and make sure we get it right. So first of all, applicant's committed to update its electric service agreement that it's filed here in the case, and that's part of the application, so it'll update the remaining documents that are in the application as well. That's going to be filed by February 27th by 4 p.m. And that's going to be filed under a confidentiality request. And in terms of making that request, we've agreed to have the applicant file the justifications for that request in a separate filing that we are expecting will be public and will be written in a way that won't reveal anything confidential. It'll just be a way to cross-check the documents filed under the request with the justifications in an easier format than we usually have in those filings. So that's the first thing. Second thing is the next step in this process would be commission staff reviewing the request and coming up with a determination. Assuming the commission approves the request, we'll have the applicant file its offered evidence, refile its offered evidence, and that'll be done in conformity with the documents, the new version of the redactions that staff approves. And then and along with the testimony and exhibits, it'll be refiling its discovery responses and data request responses to also conform to the new redactions. And at that point, we'll need to get the offered evidence from interveners and commission staff filed, and in accordance with the new redactions. And I think at that point, we'll need to see a request to modify the schedule coming in with those dates presented. And I'm assuming we can get that can be stipulated, so that should go into effect automatically according to the FMO. So that would be the date for filing, the refiling offered evidence, and with both the updated redactions and the corrections we've noted on the offered evidence list. And we'll also need new dates for the other post-hearing deadlines, like corrected testimony and witness verification affidavits. I think in terms of exhibits offered and received at the hearing, I don't think there will be any at this point, but so don't need to deal with that one. In terms of proposed corrections to the transcript, it's a little bit trickier, I think. We'll get the draft in 2 days after the last day of the party session. So proposed corrections can be done on the same time frame so that we have in the FMO. So that's really 3 working days after the draft transcript is served. So let's just use whatever date that is. And then also objections is 2 working days after the proposed corrections are served. So let's just let those days float, but I think we'll know you'll be able to set those based on those parameters. And then the final transcript won't be available until we know what the approved redactions are, because we have the confidential transcript. So we'll need to know what those redactions are, and then the applicant will need to file based on the approved transcript. After the corrections are made, we'll be sending out the final version of the transcripts. Then based on that final version, and I'll be sending that by email, and based on the final version, then the applicant files the confidential and redacted versions of the confidential volume in on IRF. So that's going to have to be after we know what those redactions are exactly. So that final confidential transcript will have to wait to an uncertain date. And I guess I can just, once we have it all packaged up, I'll just put a date in when I give you the final version to work off of, sorry. And then the briefs, we'll keep those the same at this time. So March 9th for initial briefs, March 16th for reply briefs. And then we're extending the public hearing, the public comment period until March 9th. And we'll change that on our public comment webpage, and it'll be the 9th until further notice. We'll see if, for whatever reason, we need to extend it more. I'm not opposed to that at the moment, but we'll see what the situation is when we get there. Did I get all that right? Did I forget anything?
Your Honor, the confidential filings that are coming up for the ESA and the application, we would rather see a more helpful and confidential version of the log than a more generic and public version of it. We'd like to see 2 spreadsheets with 1 column redacted, pointing to the specific term that's being redacted. It's really hard. It's really time consuming and tedious for us to be going through hundreds of pages and not understand which reasoning is applying to which term. So even though we're going to get more specific reasoning for each page and section, we still don't necessarily understand what the reasoning is for each term. And so to just be clear, I think we're going to have to see confidential versions of the explanation as well.
Okay. Well,
and maybe that creates an infinity mirror or something,
well,
but
Yeah. I think we can. I don't know that we're going to need to reference confidential information in the justification, but if we are, whatever we do, we'll make sure it's clear to staff what justification is referring to what term, and whether that's public or confidential or what. It will be clear.
okay.
okay. All right, well, we'll leave it at that because I don't know if I can realistically explain it anymore. So, great. So I will mention that for transferring by email anything confidential, we need a password. Forgot to mention that when we were enclosed, but I have one. I'm going to email it to the service list. I think that's everyone there should be able to have access to that password. So you'll see the confidential transcript when you get it served to you will be encrypted with that, and as well as the final version after the corrections are approved. That'll be encrypted with the password. I don't think I'm forgetting anything else, but we'll see. All right, so I think that's all we need to do on that. So thank you for everyone for dealing with the details of this process, and I think the record will benefit. Of course, like I said, we were fairly hamstrung in terms of moving forward without some sort of movement on reducing the number of redactions. So I hope we can get to an agreement and move forward with this in a timely and hopefully less tedious fashion than we've experienced today. But that's mostly my fault, so I apologize for dragging us all through this. But I think everyone will benefit in the end. So, so I think if we have witnesses around, we can actually start the hearing. So why don't we try? So if we need to go into closed, of course, we'll do that. At that point, I'll put out that password over the connection. But
yeah, Your Honor, we are going to call Rebecca Volk.
All right. She'll be in the same places?
Yeah, she'll.
Okay, there she is. All right. Welcome, witness Vog. Thanks for being here. Raise your right hand. I'll swear you in. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do. Thanks,
All
Judge
right.
Newmark.
Go ahead.
Thank you, Your Honor. Good afternoon. Did you file or cause to be filed direct testimony, rebuttal testimony, and one request to correct your direct testimony in this proceeding?
Yes, I did.
To the best of your knowledge, are the statements in your pre-filed testimony and correction true and correct?
Yes, they are.
If I asked you the same questions in your pre-filed testimony today, would your answers be the same?
Yes, they would.
The witness is available for cross-examination.
All right. Do we have questions? So we'll start with the interviewer. Sorry. Let me just.
Cub does not have cross-examination for this witness.
Okay.
And nor does Weeg.
None from McLean, Wisconsin.
All right. So I see Commissioner Hawkins there. Did you have questions?
I do, Your Honor.
All right. Go ahead.
Good afternoon, witness Vach. I had a question on your rebuttal testimony, and if we could pull that up, I believe it's page 6, line 6 through 8.
And so do we need to be enclosed, or is the public?
No, this should be good. If mine and Michaela's review was sufficient. So we've done our best through the discussion this morning to identify which of my questions might be for closed.
Okay, great. Thanks. Appreciate that.
But please interrupt if we fell short there.
Will do.
So in your statement, there's a pretty absolute statement made about the start date and WPL's ability to refuse service. And I'm wondering what the applicant's view is of this obligation. It seems like it's a pretty absolute statement. There's a lot of other factors like the ability to serve, the ability to interconnect a load. I'm just wondering how the applicant views the desired date of service by a new customer versus what the actual obligation is of Wisconsin Power and Light.
Sure. I think if I understand your question, there's two parts there. The first is our obligation to serve, right? So when a customer comes into our service territory, we have the obligation to provide service to that customer. The second question relates to when it's ready to take service from us. And that would be for any customer, if any improvements are necessary for that customer to be able to take service, we would endeavor to make those improvements as quickly as possible in order to start service to the customer.
And it's fair that might not always line up with their desired in-service date.
That's a fair statement, yes.
Okay, and then I believe in lines 21 to 22, you mentioned that you have to give an opportunity, you have to give prospective customers an option for taking service. In providing that option, does WPL discuss the appropriateness of existing options versus other alternatives?
Are you asking for any new customer or for this customer in particular?
I guess both.
Okay. So anytime we would have an inquiry from a new customer, we would make them aware of the applicable rates that could apply to their level of service. The same is true in the case of this customer.
And in those discussions, I mean, the case of this customer is clear, I think, in reviewing the record that they sort of fall outside of existing frameworks. Is that fair?
No, I mean, I think we identified that the IC1 tariff was an option as well as the CP2 tariff.
Okay. And then I guess going back to the obligation to serve conversation we were just having, you mentioned prospective customers coming to the territory and WPL has the obligation to serve. Is that, in your view, completely absolute? As many customers can show up as possible, and no matter the size, no matter the place, WPL has to serve them as if they were existing load and typical expansion of existing customers. I'm interested in drilling down on this view of service to prospective customers.
Certainly, if we don't have the available generation to serve the customer, or if there's infrastructure that's required to be built, that obligation wouldn't occur instantaneously. I mean, there have to be guardrails around what any utility goes out and procures on behalf of a customer or a group of customers. So I would be reluctant to make a generalization.
Okay, thank you. That's it for my questions.
All right. Anyone else have questions? Commission staff, any questions?
None from commission staff. Thank you, Your Honor.
All right, I did have a quick follow-up for you, Witness Falk, just to line up with what Commissioner Hawkins was saying. Just as a hypothetical, if there was a cap on demand for the CP2 tariff, basically the demand level would not be unlimited. Would that mean that the extent to which a customer could, and that would that if that hypothetical is true, would the obligation to serve be similarly limited?
I don't know that I understand the question.
Okay. So the CP2 tariff has unlimited a level of demand that the customer can apply for. Is that your understanding?
Subject to check. I don't have it in front of me.
Okay. Okay. So if that's the case, if there was a cap on demand that could be requested by the customer, would that limit the utility's obligation to serve that customer?
Limit insofar as they would have to take service under the approved terms of that scheduled rate.
Yes. Okay, and you agree?
Yes. Right. So we would, yes.
Okay. Yeah, that's what I was asking. Okay, great. Thanks. Appreciate that. So, no other cross. Do we have redirect?
No redirect, Your Honor.
Okay, great. Thanks. You're excused.
Thank you.
Appreciate your presence, Commissioner Vaughn. All right, next witness.
WPL next calls Logan Ashenfelter, who will be joining online.
Oh, yes, that's right. Let me find him. If you could turn your camera on, that'll help me, I think.
My camera should be on.
Ah, there you go. Yes, I see you there. Adding you and take you out of the spotlight, Sophia. All right, so let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Good afternoon, Mr. Ashenfelter. Did you file or cause to be filed direct testimony, rebuttal testimony, a correction to your direct testimony, and 4 exhibits in this proceeding?
I did.
And are the statements in your pre-filed testimony and exhibits and correction true and correct to the best of your knowledge?
Yes.
if I asked you the same questions in your pre-filed testimony today, would your answers be the same?
Yes.
Did you have a chance to review the surrebuttal testimony filed by commission staff and the other parties to this case?
Yes, I did.
I want to ask you a couple questions about that testimony. And Your Honor, if you want to bring it up on the screen, the first one I'm going to reference is surrebuttal PSC Muleman's.
All right, give me a second.
And we're on page 3.
All right. There we go.
And so there on page 3, commission staff states that WPL did not provide additional information regarding how it will seek commission approval of renewable energy procurement agreements executed under the ESA, or how generation facilities already in rate base would be used in the ESA's renewable energy procurement process. Do you have any response to that testimony?
Yes. WPL has not executed any renewable energy procurement agreements with the ICR customer. If WPL does enter into any such agreement with the ICR customer under the ESA, then WPL will submit that agreement to the commission for approval before it becomes effective. The commission can then review specific terms of the agreement and the associated resources, including as it relates to cost allocation and impacts to non-ICR customers. Whether the executed renewable energy procurement agreement is for a resource that is already in WPL's rate base or a new resource, WPL will ensure that the effect of that agreement will result in no harm to non-ICR customers. It would be premature for the commission to restrict or place conditions on the terms of any potential future agreement now before anything has been executed and brought before the commission for consideration.
Okay, and then on the next page, on page 4, commission staff notes that the record would benefit from justification regarding the current rate treatment for the ICR customer. Can you provide additional clarity on this point for the record?
Yes. Section 2 of the ESA provides that prior to the commercial operation date and the ICR effective date, WPL will furnish service to the customer in accordance with its scheduled electric rates, including the rules and regulations of WPL's electric tariff. As such, any service WPL provides to the ICR customer now, prior to the commercial operation date, will be consistent with WPL's approved tariffs, and the ICR customer will take service at a standard tariff rate that is applicable to its service requirements.
Okay, thank you. Your Honor, I'm going to move to Commission Staff Witness Field's surrebuttal testimony.
There we go.
And I think we're at the bottom of page 3. Where commission staff states, actually maybe at the top of page 4.
Okay.
Apologize.
That's all right.
Right, right. So staff states that it seeks, quote, historical and forecast transmission expense usage information for ICR customer and non-ICR customers to be itemized separately. How do you respond to that?
Yes, as outlined in my Exhibit 4, I believe that WPL has already agreed to provide this information. specifically in subparts A and subpart D of those proposed reporting requirements in my Exhibit 4.
Okay, thank you. And then also on pages 3 and 4 of Commission Staff Witness Field's testimony, Commission staff provides additional comments regarding WPL's proposed reporting requirements for ICR customer energy consumption and revenue.
I'm sorry, I kind of lost you there. Witness staff provides additional comments regarding
WPL's proposed reporting requirements for ICR customer energy consumption and revenue. Do you have any response on that topic?
Yes. Commission staff states that it is seeking information regarding the impact of the ICR customer's energy consumption on monitored fuel costs and native system requirements, which should be provided separately from non-ICR customer sales for resale. I believe WPL already agreed to provide this information as part of the reporting requirements in Exhibit 4, specifically stating that WPL will provide the ICR energy consumption and energy revenue itemized separately from other monitored fuel costs.
Okay, thank you. The next question I have for you is about Commission Staff Miller's rebuttal testimony, page 2. So there on lines 16 through 18, Commission staff proposes an additional reporting requirement related to WPL's capacity costs and demand revenues for the ICR customer. What is WPL's position on this reporting requirement?
As Commission staff acknowledges, in WPL's proposed reporting requirements outlined in Exhibit 4, WPL has already agreed to provide specifically the marginal or incremental cost to serve the ICR customer, including costs for transmission, generation, energy, and any additional costs required to serve the ICR customer, and supporting details of how those costs are determined. Given that, the purpose of this additional reporting requirement is unclear and appears duplicative of WPL's proposal.
Okay, thank you. The last piece of rebuttal testimony I want to ask you about is Cub Witness Singletary. And I'm just generally going to reference pages 1 through 5 of that testimony where Cub Witness Singletary responds to your evaluation of his proposed changes to the ICR agreement's termination charges and makes another recommendation. Do you have any response on that topic?
Yes. While I appreciate Mr. Singletary's thoughtful review on this topic, and I believe I understand his recommendation, WPL does not support any changes to the provision for the reasons I stated in my rebuttal testimony on pages 17 through 18.
Okay, and then on page 5 of his rebuttal testimony, Cub Witness Singletary asserts that a cost of service study, quote, is the appropriate tool for evaluating whether the revenues collected from a market-based contract rate are sufficient to recover all costs that are reasonably allocated to the customer taking service under the market-based rate. Witness Singletary references a commission decision in Docket 6680 TE 102 in support of this assertion. How would you respond to Witness Singletary's discussion here?
While I'm not intimately familiar with all of the facts and circumstances considered by the Commission and parties in the approval of WPL's day-ahead market pricing tariff, my understanding is that the day-ahead market pricing tariff is applicable to existing customer load that had already been included in WPL's class cost of service studies and electric rates. This means service provided to customers under the day-ahead market pricing tariff could create a situation where the revenue collected from customers for nominated load under the day-ahead market pricing tariff may not match the cost of service allocated to that amount of load in a previous rate case class cost of service study, thus potentially resulting in harm to non-participating customers through a reallocation of existing utility cost of service. Conversely, load from WPL service to the ICR customer will be new load and incremental to WPL system. Therefore, non-participating customers will only be harmed in the circumstance that incremental costs to serve the ICR customer are greater than the incremental revenue collected by WPL, and such revenue shortfall is recovered from other electric customers in rates. Consistent with the distinction I just made, WPL has proposed that the incremental cost of service to the ICR customer shall be assigned to that ICR customer in a future rate case class cost of service study, and that all rate revenue associated with service to the ICR customer shall be reflected as part of WPL's retail electric revenue requirement in a future rate case class cost of service study. This means that non-ICR customers will be insulated from the incremental costs and will only receive the upside benefit for revenue that exceeds the incremental costs. Mr. Singletary appears to hedge his argument with the proposed inclusion of a nebulous concept of incremental embedded costs in WPL's proposed incremental cost test. This appears to be nothing more than a different way of imposing his preference of allocating costs to the ICR customer through an allocated class cost of service study with the word incremental added, and for the reasons I stated before and in my rebuttal testimony, should be dismissed.
Okay, thank you. I just want to ask you a couple more questions on a topic that I know Commission staff is interested in. And some of this, Your Honor, I don't think we need to go into a closed session here, but there is a reference to some confidential information that I'm going to just reference generally. So
no problem. Go ahead.
Thank you. So Mr. Ashenfelter, on page 36 of your rebuttal testimony, there is you're referencing a component of the ESA. I'll refer to it for shorthand and to avoid the confidentiality issues as a minimum charge. Okay, and you say that minimum charge, quote, is a negotiated risk allocation mechanism that has commercial trade-offs to both parties. When you say commercial trade-offs, what do you mean by that?
I would start by stating that both the customer and WPL consider the balance of the total commercial package when considering individual components of the terms of service, which includes minimum charge commitments imposed by WPL on the customer. With respect to these minimum charge commitments, the desire of WPL to have stable and predictable revenue, along with the customer's desire to only be charged for service that is used by the customer, are not entirely congruent. In practice, this means that imposition of higher minimum charges shifts the risk allocation to the customer and is typically paired with a desire for reduced margin rates for service, including the ICR demand charges.
So as part of these negotiations, how did the parties determine that the trade-offs were reasonable?
The existence of the minimum charges provides an appropriate and meaningful incentive for the customer to request a realistic level of service, which improves utility system planning and revenue stability, and ensures that the customer does not needlessly reserve system capacity that could otherwise be utilized by other system customers. Further, WPL has an integrated system of nearly 3 gigawatts of diverse customer load, where underutilized capacity from one customer can be used to meet the increased demands of other customers, which can have the effect of mitigating any net impact to the overall system load.
Okay, and for unutilized capacity, are non-ICR customers responsible for compensating WPL for this margin of capacity if the ICR customer's load falls below the threshold specified in this minimum charge?
No. Practically speaking, the application of these minimum charges occurs on a real-time basis based upon actual consumption levels of the ICR customer, and I'm not aware of any circumstance where such a reconciliation would result in non-ICR customers compensating for any difference.
Okay, thank you. That is all I have for the witness, who's now available for cross.
Okay, any questions? We'll start with interveners. Cub?
Yes, Cub has a couple of questions for the witness.
Let me spotlight you. Okay, go ahead, Attorney Narvi. And just introduce yourself first and go ahead.
Good afternoon, Mr. Ashenfelter. My name is Daniel Narvi. I'm an attorney for the Citizens Utility Board. Referring back to the Sir rebuttal testimony you just gave, how will WPL identify what costs are incremental costs that are attributable to the ICR customer in the future?
Sure, thank you. I would imagine, WPL in my direct testimony, laid out some options for how incremental capacity costs or marginal capacity costs could be evaluated for service to this customer. Sorry, just trying to wrestle in my mind what's public. For a period of time, clearly the ICR demand charges are based upon market-based prices or a derivative of market-based prices. And I think that's pretty easy to connect with marginal capacity costs. As I've said throughout testimony, there's also could be circumstances where incremental resources are added to the system. And in that circumstance, it certainly could be considered that some portion or all of an incremental resource could be evaluated as part of incremental capacity costs for the ICR customer.
So would the cost of new generation assets that but for the ICR customer's load would not be needed be counted as incremental costs?
Yes, certainly could be part of the evaluation where, if it was determined that there was a need for additional capacity resources based upon the system needs, that could be accounted for as incremental costs.
You said that it could be part of the evaluation. How would the company evaluate that to determine if they should be considered incremental costs?
Well, it would likely depend on the specifics of the resource, size being namely one. I wouldn't anticipate a circumstance where a new resource would 100% match a specific amount of load for the customer. So there would likely need to be some form of portfolio analysis included as part of that assessment.
in that circumstance, would the company evaluate its resource portfolio with and without the ICR load to make that determination?
I mean, at that point, presumably the resource has already either been constructed or is in the process of constructed, and perhaps even received some level of approval from the commission to construct. So the portfolio analysis presumably has been completed at that time. I'm more or less, stating that, say it's the next incremental resource, it may not one for one line up with the amount of load associated with the customer. So there may need to be other considerations, I guess, in how marginal costs would be determined.
So in making that determination about incremental costs, would the company's approach be to evaluate its resource portfolio, both one considering its needs with the ICR load and in contrast considering it without the ICR load?
I'll say I'm not the resource planning expert, but I wouldn't anticipate that to be the case. I'd more suggest that once the ICR load's incorporated into WPL system, that WPL is planning for the system as a whole and not for any specific customer.
Okay, thank you.
Other interveners, questions?
No.
No, okay. Looks like Commissioner Hawkins has a question, so go ahead.
I do. Thank you, Your Honor. And again, I am doing my best to separate out questions that require closed treatment versus not. But I have some questions on transmission charges, which I believe are all public components of your testimony. So I will start, I think, with your direct testimony, page 13. Specifically lines 17 and 18.
Give me a minute, Commissioner. I'm going to get that on the screen for us.
Absolutely.
Please provide the page number one more time.
It was page 13.
Thanks. Okay, I think we're there. Go ahead.
Yep, line 17 and 18. So in your direct, in response to the question about how costs for transmission are recovered, you stated that your understanding was that once construction is complete, that those costs would flow into rates. Later in your rebuttal testimony, you seem to recognize what staff was pointing out, that costs can flow into transmission rates before construction is complete. Is what you stated in your rebuttal testimony your final understanding of how costs from transmission can flow to customers, that it's not necessarily related to the timeline of completing construction?
Yes, you are correct. I am aware that specifically for ATC that they are allowed to include construction work in progress balances within their rate base that determines their network service rates, including the costs for the transmission facilities identified to serve this ICR customer.
Okay, and then sticking with the rebuttal testimony on page 30, you stated that it's not entirely accurate to suggest that non-ICR customers will pay for transmission charges during construction. You also stated that those costs flow into the rates ahead of construction completion. And then you point out that there's a true-up that happens through the typical transmission escrow process. So I'm curious as to which part of staff's statements were not accurate.
In particular, the regulatory lag component of that. WPL in its most recent rate case set rates for 2026 and 2027. As part of that rate case, there is an approved process for a transmission escrow that would account for changes in transmission costs relative to the approved amounts from the rate case. So the concept that I'm trying to lay out here is that yes, WPL may incur costs during that time frame. The impact on customers won't occur until presumably the next rate case, and presumably when the commission has an opportunity to review the transmission escrow, including the costs and revenue collected from the ICR customer.
Isn't it correct that the impact to customers occurs based on the best estimate at the time for the planning years, and that the exact impact to customers doesn't happen until years later or after the transmission escrow?
I would agree with that.
Okay, so you said there may be an impact to customers. We know there will be, isn't that right?
I think the point I was trying to convey was that WPL has proposed to include incremental revenue collected from the ICR customer as an offset to the transmission escrow, so that there is the opportunity that revenue collected could completely offset any incremental costs incurred during that time frame.
And you're talking about pre-construction, pre-getting service.
I'm talking as the ICR customer receives service from WPL.
Okay, yeah, my question was about the construction timeframe and specifically focused on transmission costs prior to the facilities being energized.
I guess I'm failing to see the distinction that you're trying to make.
I was trying to understand the customer impact prior to service to the ICR customer. And I think your response was over a broader timeline.
Correct. I wouldn't anticipate a customer impact until 2028. And even at that point, it's unclear if there will be an impact at all.
So the estimated Schedule 9 rates that you have as a exhibit that you state are inclusive of the construction costs that were part of the latest rate case don't have any costs associated with the facilities to interconnect?
Oh no, my anticipation is that they do. The rates that we provided as an exhibit, and of course, those are rate forecasts that ATC updates regularly and provides updates for.
Okay, and so those costs would be recovered by customers, not by the ICR customer.
I can't say for certain whether those were the rates or costs that were factored into transmission rates that are in customers' rates today.
Okay. And then in your rebuttal on page 30, line 8, which I think we have here. Yep. You state that more broadly, ATC inclusion of QUIP is FERC jurisdictional, and I'm wondering if you are aware of ATC's ability to unilaterally change how those costs are recovered.
I can't say for certain, but I would suppose that they could propose a change for their rate making treatment, and then that proposal would be subject to approval from FERC.
Okay. And are you aware of how all other transmission owners in the MISO region recover their transmission financing costs?
I'm not aware of for all. I am aware of others that do not include QUIP and rate case, or sorry,
I'm sorry, that do not include QUIP and rate?
QUIP and rate base for rate making treatment for their network service rates.
Thank you.
So I don't know if ATC is unique in this regard, but I do know that others, other transmission owners do treat that component differently.
Okay. And would you say it's fair that for large projects such as this one with large infrastructure on the transmission side required and corresponding large load additions, that the financing impact and the timeline of recovery is uniquely impactful to customer rates?
Yeah, I don't know about uniquely impact. I'd say for larger projects, they may be completed in stages. For example, interconnection facilities could be completed on a more accelerated timeline, with broader network upgrades needed to be completed over a longer duration time frame. And in that circumstance, if interconnection facilities are complete, there is an opportunity to connect a customer and attempt to receive revenue that could be offsetting of any of the costs, including the impact of inclusion of QUIP in rate base for determining the transmission owner's rates.
Okay. And I want to pivot now to, I guess, just transmission cost allocation more generally. And it's in your rebuttal pages, page 28, line 20. You state that there is no mechanism in the MISO tariff that authorizes the costs of these facilities to be directly assigned to the ICR customer. And Your Honor, if we could bring up the document that I submitted in advance, the MISO tariff attachment FF.
All right, let's go off the record. I have to admit, I don't have that right in front of me, but we'll get it. Go. Okay. So we're looking at the attachment FF, you said, right?
Yep, PDF page 49.
Okay. Okay. I think we're there.
Thank you. So on the screen is section D here, is the description of a market participant funded project, which states that projects can be fully funded by one or more market participants. And I'll give you a second to review it if you'd like. But my question after your review would be, is Wisconsin Power and Light a MISO market participant?
Yeah, I'm curious, Judge Newmark, if you could expand the text a little bit for me.
Okay, just to lower. Oh, you can't see it. Is that what you mean?
Yeah,
it is pretty small.
I can try. Yes. Some of these documents.
But to answer your question, Commissioner, yes, it's my understanding that WPL is a MISO market participant.
Okay, so then, if this project type here allows for transmission costs to be directly assigned to a MISO market participant, would it be fair to say that the MISO tariff allows for transmission projects to be directly assigned to WPL?
Yeah, potentially. I'll tell you, I'm not familiar intimately with attachment FF here or this specific subpart. But it appears that there is an opportunity, if not for load related projects, but perhaps even generator interconnection or network upgrades for generator projects.
And then just going one step further, is it fair to say that the commission can allocate transmission costs that are assigned to WPL amongst various customers and customer classes?
Yes, I'd agree that it's the commission has broad authority determine just and reasonable rates for the utilities cost of service.
Okay. That's it for the MISO tariff, and I certainly sympathize with the length of the document and unfamiliarity with it. So apologies for springing that. The next item, Your Honor, could we bring up the concurrence from FERC Commissioner Chang that I provided in advance?
All right. First, I just wanted to introduce that MISO tariff. I think in the past case we were dealing with WEPCO's proposed tariff, we did enter this same tariff as enter the MISO tariff as an exhibit. So I'd like to do the same thing here. So if we have a Ashenfelter 5, we'll mark it as that, and let's go off the record. If that's true, we did put that in. I don't know if Eric's.
You're asking whether I'm sorry, whether.
I don't know if you're going to know this. Yeah, we in the WEPCO case, we dealt with this tariff as well, and I think we had marked it for the record, but
Yes.
Yes. Okay.
In the WEPCO tariff, yes.
Yeah. Okay. Good. Thanks. So let's back on. So yeah, just to be consistent with the record's complete, we'll mark that Ashenfelter 5. So any objections to receiving that MISO FF tariff? Okay. Hearing none, we'll put that in. I just don't think I filed it yet. That's the issue. Okay. All right. I'm sorry. Let's proceed then. The Chang concurrence. Let me get that on the screen. There we go. All right. So sorry for interruption, Commissioner. Go ahead.
No apology necessary. I think if we could just scroll down to make sure that the third paragraph is showing. Thank you. So in your, let's see here, I think it's in your rebuttal where we just were in page 29, somewhere on there, you state that FERC has exclusive jurisdiction to regulate transmission rates. And I wanted to bring this piece of evidence from a recent FERC decision related to FERC's authority over transmission rates, where the commission makes it clear and emphasizes that alignment between state and federal authorities should not allow transmission owners to create jurisdictional silos that prevent states from being able to protect retail customers. Particularly in this FERC final order and in this concurrence, it shows in my reading that FERC is very open to working with states to protect customers. And I am just curious, in your statement on FERC's exclusive jurisdiction to regulate these rates, what your position is as far as WPL and the state commission's ability to eliminate silos and potential unintended consequences of transmission cost allocation.
I'll tell you, I have a hard time, I guess, reading that excerpt and hearing your description and understanding how that, I guess, changes, FERC's jurisdiction. Certainly understand the concept of collaboration and, determining the appropriate, whether it's allocation or eliminating silos, as you suggest.
Understood. Fair enough. That's all I had on that one.
Okay, so let's mark that Assenfelter 6, and any objections to that in the record? Okay, we'll put that in then as 6. Go ahead, Commissioner.
All right, my last and final question on transmission is related to the response to data request Laura Witzling 2.6, and I'm not sure if we checked if this one is confidential or not.
Okay, we should have a public version of that. Let's see. So is that in your, let's go off the record. Is that in your email?
No, this is.
Okay.
Oh.
All right.
It shouldn't be confidential. We did review this.
Okay. We should have both versions, hopefully. And let's see, it's
2.6, you said?
Oh, and actually, yeah, I think in that response, it's referenced. We want to look at exhibit Ashenfelter 1. Which I'm not sure if that is confidential or not.
there's a public version we can display. So, and it was, what was the data request response labeled?
Laura Witzling 2.6.
It was LCW.
I'm sorry.
That's okay. And there's no redactions in it.
I'm not seeing that. So I see LRM.
It's on page 8 of 10.
Oh, okay.
LCW. Yep.
2.6, you said? 2.6, is that right?
2.6, and if I understood, the question was about the data request itself and not, or I'm not seeing any redactions in the question itself, but
Right. Okay.
Okay, perfect. All right, thanks.
Perfect.
So back on the record.
Thank you. So this question was asking the applicant for an analysis of those financing costs that we were talking about earlier. And in the limited, go ahead.
I think that's 2.5. I'm not sure why it says 2.6 at the top, but that was an answer to 2.5. You want to keep scrolling?
Oh no, this is right.
Okay, it's misidentified in the response.
Okay. Well, luckily, this is what I was talking about.
That's good.
So here, commission staff asked for an analysis of those financing costs, which wasn't provided on my review, but you did point to your exhibit, Ashenfelter 1. And stated that might contain the information, and so I have a question about that exhibit, and particularly Schedule 2 of Ashenfelter 1.
And Your Honor, here we may need to go into confidential session to the extent these questions are going to get into specific numbers or what have you.
Okay. Yeah, I guess there's not much being displayed here. Okay.
Oh yeah, I can hold this one. I have a group of confidential questions, so maybe it'd be best if I.
Okay, if you don't mind grouping those together, that would be great.
Okay.
Okay.
Sorry about that.
No, not at all.
So my next question is on related to distribution costs. And in your rebuttal on line 4 or page 4, lines 13 and 14, you stated that WPL expects that the only distribution investments will be metering, and I think that's referred to all over. Sorry, that was page 4.
Oh.
Line 13, sorry.
Oh,
And for this, Your Honor, I'd like to pull up the final decision in docket 137 CE 100 that I provided in advance.
okay. Oh, one. No, that's C100.
Oh, it is 210. Sorry.
Okay. Yeah.
My notes were incorrect, but we sent you the correct thing.
Okay.
So page 13 in particular. There we go, project description. So here in the project description of this Dodge County project, as it's referred to, it describes that the equipment, there will be a substation owned by ATC. It also states that there will be 2 new customer-owned load-serving substations. And I'm wondering how WPL-owned substation costs are typically recovered.
Is your
Go
ahead.
Sorry, I was just going to object to the extent, I don't know that customer owned and WPL owned is synonymous.
Looking at the phrase on, oh, there's no line numbers. Okay, yeah, the third line from the bottom of page 13 refers to 2 customer-owned load-serving substations, and you're looking for clarification about if that's Wisconsin Power and Light as the customer or the load source as the customer?
Correct.
Okay. I guess
I would be open to hear from staff on this. My understanding in ATC cases, customer owned is typically refers to the utility customers of ATC.
Okay.
that could be perfectly.
I could point you to middle page 14. The project is needed to serve a large load interconnection request by WPL to serve a new large load addition in the Beaver Dam area and maintain system reliability. We can find some discussion of the substation if that's helpful. Or 2 substations.
Well, is that enough for the applicant to be able to answer the question? I guess we can.
Yeah, I think the witness can answer to the extent, he has personal knowledge to answer.
Yeah, I think the question is more generally speaking too, I think, but let's see what the witness has to say and we'll take it from there. So go ahead, please provide your answer. And if you need the question read back, we can do that too.
Well, I think the question was, how does WPL recover substation costs?
That's correct.
Right. And so if there are distribution substations, those would be, recovered from distribution customers through the cost of service. I think, based on the context here, there is reference, I see it in the bottom of the page. It says 2 new customer load serving substations. I can say that I'm not aware of any distribution substations, so WPL owned substations as part of this, interconnection of the ICR customer. The ICR customer is required to take service at transmission voltage, and that point of interconnection would be at the transmission owner's substation, and the ICR customer would be responsible for any facilities beyond the point of interconnection.
Okay, so in this decision, we did approve one of those transmission owner substations, and that's mentioned here, the Manhattan substation. And then it refers to these 2 additional load serving substations that are also part of this project, and you're not familiar with those, or you don't believe they exist.
Well, I know that the ICR customer will construct and own their own substations for taking service at transmission voltage and converting it or transforming it to whatever their electrical requirements are. WPL does not own that substation.
Okay. Thank you. That is helpful. And then
added to the extent to the extent you may get new information that makes you change that answer, I guess let Attorney Rogers know, and we'll figure out how to adjust that, because I think that's an important point. Just in case your that question's not complete, if the company can just verify that and get back to us.
If I may, Your Honor, I'm just taking a look through the record of the Dodge County construction project, and this isn't in the record here or being offered, but in the application, there's some clarification that confirms the customer that wording. It should have said end use customer. It was not WPL that we were referring to in that final decision.
Okay. I think that's good enough, so that we have that verification. We'll just use that representation from commission staff to clarify, and we can move on. So
thanks, Your Honor.
Thanks for looking that up. Okay, proceed, Commissioner Hawkins.
thank you. That is all I had on the distribution costs. And then I think my last non-confidential is related to energy and demand charges. In your rebuttal testimony, page 6. Let's see here. Yeah, so just the concept there on line 16 and 17 of additional revenues and excess cost benefiting other customers. I think this is in your response as well to commission staff Muleman's, where there's a recognition that incremental revenues from new load will not benefit existing customers until the next revenue requirement is set in a full rate case. Is that your understanding?
Correct. Incremental costs wouldn't be factored into a cost of service, nor would incremental revenues.
And then I think in your responses, you also stated that the earnings sharing mechanism provides a backstop to ensure benefits to non-participating customers. And I'm curious if in the past rate case, if the addition of this new load and potential scale of revenues and costs was contemplated in the previous rate case at all.
Was the load or the costs or the revenue included in the test year revenue requirements or cost of service in the previous rate case? To my knowledge, the answer to that is no.
Okay, and you mentioned that, you know, the typical rate making process in Wisconsin, you know, contemplates different costs and revenues changing throughout the test years. But is it fair to say that the scale of this load and the associated costs and revenues are not typical of what's accounted for in a typical rate case?
I'm sure that's a matter of, you know, subjection, but I couldn't agree with that.
Okay.
I'm sorry, but I could agree with that. Or could.
Yes, I could agree with that.
Thank you.
All right, and that's all I had that can be in open.
Okay. All right, let's move into closed.
Your Honor, I'm sorry to interrupt. We have a witness who had an emergency come up, and
Let's go
would
off
like,
the record.
thank you.
Yeah, go ahead.
Jolene Scheel needs to pick up a family member, and she hasn't been we haven't been notified of any cross for her. If we could take her real quick, or if you could excuse her and have her do an affidavit, we would appreciate it.
Yeah, I think best course of action would be to have the witness verify by affidavit if we have no cross. So let's go on the record just to verify. Attorney Rogers indicated that witness Scheel will may have difficulty appearing at this time. We could probably, let's just ask if there's any cross at the moment for this witness as we sit here today. Otherwise, we'll have the witness verified by affidavit.
None from WPL, Your Honor.
Right. Anyone? Doesn't sound like anybody else. So okay, great. So we'll take witness Shield's verification by affidavit, and that witness is excused for emergency.
Thank you, Your Honor.
All right. Is there anything else we need to address in public before we go into closed? Okay. So we'll do the same drill as before. We'll get everyone into the breakout room, and I'll announce now to the public watching the live stream that will be enclosed. So you'll see nothing on the live stream until we're back in the public session. And this probably won't take very long, but just so you know, we will be back in public when the time comes. So everyone will be in the breakout room. I think there's nobody that we gotta let in.
I'm gonna grab something while you're doing that.
Yeah,
I'll be quicker than you are.
Yeah, probably. We're off the record for now. Doesn't look like anyone here is someone I don't recognize as a party or commission staff. So we'll let everyone into the breakout room and start from there. Okay, well, we'll stay off the record for a minute. Just take a brief stretch. We'll wait for the court reporter. Oh, I'm not in the room yet, am I? What's going on?
You're on mute.
I'll get muted. Okay. Back in open session, and we've had the witness was just cross-examined. So let me just have let's just have for the, well, I guess that's fine. We've already asked in the closed session. So there's no questions for the witness in public, either no remaining cross or redirect. So we can excuse you. Thanks very much for participating. Appreciate all the answers you gave us. All right, so that's the applicant's witnesses. We have checked in all of the intervener witnesses, so that leaves us with commission staff. Let's just go off the record for a second. So we are approaching the 5 o'clock mark, and I know we do have some more witnesses to take. I didn't think there was any cross for staff witnesses, but staff may have additional testimony. So just curious, Attorney Rogers, how long do you think we have for the remaining witnesses here?
I think we can certainly make 5 o'clock. We have two different clarification questions that will be quick.
Okay, and
non-controversial.
Confidential or public?
Public.
Okay, all right. Well, maybe this will occur pretty quickly then. So let's press on with commission staff.
Thanks, Your Honor. Not seeing the alphabetical list before me, I'm going to pick on Tyler Mellemans. Commission staff calls Tyler Mellemans to the stand.
Okay, let me get you. Okay, let me swear you in. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do.
All right, go ahead.
Please state your name for the record.
Tyler Mellemans.
Did you file or cause to be filed direct testimony, sir rebuttal, and one exhibit in this case?
Yes, I did.
Are the statements and representations in the testimony and exhibits you filed true and correct?
Yes, they are.
Do you have any additions or modifications at this time?
Not at this time.
So just one clarification question for you, witness Mellemans. How can you provide some precedential background on market-based rates? We've had some discussion about whether market-based risks must be taken for capacity and or energy. How has the commission viewed this issue in prior dockets?
Yeah, I'm happy to provide some context there. So the commission has authorized a host of, market-based rates of a variety of flavors. This has occurred for some of our investor-owned utilities. So at a bare minimum, WEPCO, Wisconsin Power and Light, Wisconsin Public Service Corporation, and then beyond our IOUs, we also have a fair amount of municipal utilities that offer a market-based rate, that being the NLMP or new load market pricing rate. I was able to do a bit of a review throughout this hearing today, kind of looking at some of those tariffs that are currently out there. Based on my review, I was able to identify the real-time market pricing rider and the real-time pricing rider for WEPCO. Both of those, from my review, appear to be market-based rates for both energy and demand. For Wisconsin Power and Light, I identified their day-ahead market pricing rider as well as their NLMP. Based on my review, it appears that both of those tariffs are market-based rates. Both of those do notably include an adder for what is referred to as like a resource adequacy charge, and that's assessed based on demand. For Wisconsin Public Service Corporation, they also have an NLMP and RTMP. Both of those, based on my review, are largely market-derived. The RTMP, I'll note, does have a set transmission rate, which is sort of taking the place of demand there. In the text of the tariff, it states that this rate is derived from the market cost based on transmission. And then lastly, for a whole host of municipal utilities, we have their NLMP rider is market-based for both demand and energy rates.
Thanks, witness Mellemans. Open to cross. Oh, I'm sorry. I take that back if I may. I'd like to have the witness also sponsor the data request response exhibit, if that's okay.
Oh, just in general? Sure.
Yep.
Yeah, that's okay. So,
I can ask him to do that.
Sure, go ahead.
Witness Mellemans, did you also cause to be file or cause to be filed the DRR exhibit?
Yes, I did.
And are the statements and representations in that exhibit true and correct?
Yes, they are. Subject to all the confidentiality changes that are coming.
Yep. And then this is more of a staff and ALJ process, but the public comment exhibit, can you go ahead and sponsor that as well?
Absolutely.
All right. No further questions.
All right. Okay. So do we have any cross for the witness?
Judge, I did have a couple questions just based on the witnesses. Sir, I guess, whatever you want to call it.
I don't know what to call it. Go ahead.
Good afternoon, Mr. Mulemans. My name is David Zappo. I'm representing WPL in this case. So I think you just mentioned that you did kind of a review of market-based pricing tariffs for various utilities throughout the state. In the course of that review, were you just reviewing the tariffs themselves, or commission decisions approving them, or what did you look at, I guess, to collect that information?
Yeah, primarily the tariff language itself.
Okay. Did you have occasion to review the commission's decision approving a market-based rate between WEPCO and Charter Steel?
I'm going to need a little more specifics there to know what you're referring to. Like, is there a docket number you can point us to?
I don't have the docket number in front of me. It would have been, the approval would have been 10 years ago or longer.
Yeah, I was not at the commission over 10 years ago. I without knowing exactly which document you're speaking to, I can't confirm or deny if I've reviewed it.
Okay, but you just mentioned that you were primarily looking at the tariffs for these market-based rates for the various utilities. Is that correct?
Correct.
So during the course of that review of those tariffs, did you happen to review any other document related to a market-based rate between WEPCO and Charter Steel? And this, I guess for clarification, this would have been in docket 6630 GF 132 in 2010.
Is that G like George, F like Frank?
Correct.
Thank you. Sorry, go ahead, Mr. Mellemans.
I don't recall reviewing that specific document.
Okay. I think you had also just mentioned that, so during the course of this review, you had looked at, I believe it was Wisconsin Public Service Corporation's market-based tariffs. Am I recalling that correctly? Is one of the tariffs you reviewed?
Yes, I did review Wisconsin Public Service's tariff book.
And for their market-based rates, those have, I'm just trying to clarify what you had said were in those tariffs. Those have market-based energy rates. Do I understand that correctly?
Correct.
And they have specific transmission rate. Is that what you had said?
In the RTMP tariff, there is a set rate that you can see on the tariff itself, as opposed to like a lot of these other tariffs where it says essentially this is a pass-through of ATC, MISO costs, etc. Yes, the Wisconsin Public Service RTMP tariff has a set transmission rate. The text surrounding that rate denotes that this is based on, like, I can't remember the exact verbiage, but it's based on like real transmission costs from ATC, I believe.
Okay. What about demand charges? Are those fixed? Are they market-based?
My interpretation of the tariff, and this is certainly subject to change, or subject to a little closer review, but my interpretation of the tariff was that the transmission charge is representative of the demand charge. I don't recall seeing a separate section for a demand charge. I would want to double check that to be absolutely positive there, but I believe that tariff is just a transmission charge that's kind of serving the purpose of a demand charge.
Okay. No further questions.
All right, thanks. Any other cross? Redirect?
Your Honor, I think it might be helpful to have some clarity on that. I think that's a good question. Maybe we can get just a couple minutes off the record for the witness to go in and confirm that.
Okay, off the record.
I've had a chance to review it. I certainly misspoke.
Let's get back on the
Sorry.
record.
Thank you.
So do you have any? Go ahead, Attorney.
Yeah, Witness Melamans, you just had a couple minutes to take a look at that tariff you were just asked about, the WEPCO real-time market pricing rate, and do you have any revisions to your statement made a few minutes ago?
Yes, I appreciate the additional time to review the tariff again. There are standalone customer demand charges. Those are, as outlined in the tariff, it just says CP rate schedule. So that would lead me to believe that the demand charges here are set equivalent to that in a CP rate schedule.
No further questions.
Okay.
Can I just add one follow-up question on that?
Yep.
So if it's referring to, well, first of all, I think Attorney Rogers referenced in her question said WEPCO tariff. This is a WPSC tariff, correct?
Correct.
Wisconsin. Okay. And then, so if those demand charges are referring to the CP rate, that would suggest that the charges are fixed. Would you agree with that?
Subject to check, that is in all likelihood the case.
Okay, thank you. Nothing else.
Okay, thanks. All set.
Yeah, I don't think we have to go back and check that.
Okay, all right. Okay, thanks very much. You're excused.
Thank you.
Yep. Who's next?
Commission staff calls Andrew Field to the stand.
Right, just give me a second here. Here we go. Good afternoon. I'll swear you in, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name.
Andrew Field.
Did you file or cause to be filed direct testimony and serve rebuttal testimony in this docket?
Yes, I did.
And are the statements made in your direct and serve rebuttal testimony true and correct?
Yes, they are.
Do you have any additions or modifications at this time?
No, I don't.
Open for cross.
Any questions for the witness? No? All right. Thanks. You're excused.
Thank you.
Commission staff calls Will Coble to the stand.
All right. Raise your right hand. And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Oh, you're muted. Let me see if I can. Where's my list of people?
Can you hear me now?
Oh, yes. Okay. So that was a affirmative to my question. Yes?
Yes.
Okay, excellent. All right. So your volume's a little low. Maybe if you just speak up a little more, I think we'd be able to hear you. But go ahead, Attorney Rogers.
Witness Coble, sorry, I don't think we did your name. Please state your name.
My name is Will Coble.
It is pretty low, but we just have a couple more questions, so we can just speak up. Okay, did you prepare and file or cause to be filed direct testimony in this case?
I did.
Are the statements and representations in the testimony you filed true and correct?
They are.
Do you have any additions or modifications at this time?
I do not.
Open for cross.
Any questions? No. All right. Thank you very much. You're excused.
Commission staff calls Lincoln Miller to the stand.
Okay, have you there? I'm going to unmute you. All right. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? No, I'm not hearing you either. What did I do here? You look unmuted on my end. Maybe it's your headset.
Okay, we can try that again.
Oh, excellent. Okay, all right. Yeah, let's do it again. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Great, thanks.
Please state your name.
Lincoln Miller.
Witness Miller, did you file or cause to be filed direct testimony, serve rebuttal testimony, and 4 exhibits in this case?
Yes, I did.
Do you have any, are the statements and representations in the testimony and exhibits you filed true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony or exhibits at this time?
No, I do not.
Open for cross.
Any questions? No? All right. Thanks very much. You're excused.
Thank you.
Jolene, Sheil had a family emergency earlier, and we said we would, she to pick up somebody. I'm not sure if she's still on.
Get into the details. That's
No,
okay.
sorry.
Yep, we're good. Yeah, she'll just verify by affidavit. So is that all of our witnesses?
Yeah, sorry, I was hoping she might be on and we could skip the affidavit, but she's not.
No luck there. I
Yep.
haven't really checked.
So that's all the witnesses that staff has.
All right, great. So so let's just recap. I think I'm not going to repeat any of the post-hearing provisions and process that we've set up earlier because I just don't want to run the risk of contradicting myself. But review, we'll have the draft transcript up and running in a couple days. So review that for more details, but we will expect to see the filings we've agreed to, and and let me say that I will accept that. I don't think I actually said I'll accept this process, so we'll accept the process we discussed before, and we'll expect that updated filing at 4 p.m. tomorrow from the applicant. Also, we will then await the rest of the refilings as we've presented in the earlier portions of the hearing. I think that's all. I will be providing you guys a password for to encrypt your confidential documents when you are serving them by email. That you'll just get that in a few minutes. Otherwise, I think that's all. Is anything else we need to address before we adjourn?
Your Honor, I do have one thing. Hopefully it's very quick. Just going back to the discussion about public comment, came to my mind that the public comment has a affirmation that someone has only submitted one comment pursuant to the notice. So I'm wondering if there will be a new notice or if there's any way to accommodate folks who commented before new information was available.
Yeah, that's a good point. So because not everyone's watching, and I think the only way people are going to know that the comment period's opened or extended is by having watched this this proceeding on YouTube or getting the recording. I'll issue sort of a memo order that'll say, you know, the comment period is extended. Yeah, and I can indicate if people have additional information based on the new versions of documents, I'll accept a second comment. But again, the problem is we don't know when we're actually going to have that available to the public, if it's going to meet the comment period deadline, and I don't know how far we can extend it, you know, out into the future. But we'll keep it at March 9th for now, and then we'll see where we're at that point. So, yeah, I mean, I'll work up some sort of language that'll let people, you know, file a second comment. Hopefully not repeating the first one, but yeah, thanks for raising that issue. I'm glad you're thinking about it. So, does that help?
Yes, thank you.
Okay. All right. So, anything else? All right, great. Well, thanks everyone for living through this. Certainly a hearing to remember, either in probably in infamy, but let's move on. We'll expect those new filings, and we'll take it from there. So thanks very much, everyone. Take care, and we're adjourned.
Thank you, Stan.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
You're out.